person does that. And part of this is trying to make sure that when someone makes a sale in contravention of these pretty basic, and I would hope universally agreed upon principles, that liability in fact should attach. That's what this bill does.
Senator Richardson.
Thank you, Madam President. I'd just like you to try to understand why manufacturers are on here. If you use the analysis of a car dealer selling a car to somebody who's intoxicated, I understand that, but the manufacturer of that car did not know that the dealer was going to do that. So why is manufacturer on this?
Senator Townsend.
Thank you, Madam President. I want to only use the car and gun parallel to the extent it makes sense to do so. I think this is an example where I'll use Uvalde as I understand it, that if, for example, a gun manufacturer or a gun distributor were to be doing certain kinds of marketing with certain kinds of content targeted at certain kinds of individuals, and then it results in harm, I believe very much that that should be up to a jury and judge to make a decision whether or not that was reckless. And so, again, this is not strict liability. I don't know if a car example can be used so much. I mean, there might be certain kinds of cars that can be marketed to someone in a certain kind of way where a purchase immediately results in harm, although I largely doubt it. I don't think that parallel works as well here. But I certainly think we have seen instances where there's reason to be concerned by the way in which certain products are marketed in a very targeted way that, I think very knowingly could lead to harm. One could argue it's reckless. And so this legislation does not say that, hey, if you put an ad out and the gun is used in a crime, you are liable. It's much more, it's a much deeper issue than that, requiring all kinds of other findings by a jury.
Senator Richardson.
Thank you, Madam President. I can't think of any example where someone who manufactured a firearm could promote it in such a way as to knowingly know that it's going to cause harm to another person. Can you explain that, please?
Senator Townsend.
Thank you, Madam President. I will try. So just as a brief addition to what I just said is that you could take a look at certain demographics of individuals or certain communities on social media that someone might belong to. You can put an ad together in a way that markets a firearm as a certain kind of usage. There are ways in which you might choose to market or promote or distribute your products that the community, and so when I say the community, I'm referring ultimately to juries, would look at and say, that was just outright reckless for you to do that. And so I know there's a sort of quizzical reaction. I mean, I don't have a website in name or a community group in name that I'm thinking of, or frankly would want to even specifically name. The point is that we have instances in which marketing products to certain groups of individuals, certain age ranges, certain communities, not just who you're marketing to, but how you're saying it, could be something that would, I'll say shock the conscience perhaps, but in a different way in a courtroom, a jury might say that was reckless for a manufacturer to do that. And again, Senator Richardson's question, I'm sure with additional time, and I just mean seconds, although I don't want to belabor the point at all, find additional details or examples if you'd like to, but there, certain ages, which is part of the motivation for other legislation, or certain communities where if you're saying, hey, this gun will do this, and if you're doing it in a community group, a bulletin board, something where there's reason to believe that leads to harm, has led to harm, that is something that a jury could look at and say that was not appropriate. So if you're looking for more details, Senator Richardson, I'm not going to go into specific group names at all. But the point is that the sort of micro-targeting and what you say, I think very much in the community could cause concern and meet these legal standards.
Senator Richardson.
Thank you, Madam President. I guess in this case, and in a lot of cases, when there's a lawsuit, you look for deep pockets. And I guess a gun manufacturer would provide some deep pockets. So I just think that, adding the manufacturer to this is unfair to the manufacturer. That's all. Thank you.
Okay. Senator Townsend. Senator Hocker.
Thank you, Madam President. I'm very concerned about this bill as a business owner. And yes, I do sign the front of the paychecks, and that's why I decided to run for election and be part of this body, because it makes a huge difference when you do. And you've heard me say before, of all the General Assemblies I have sat in, this has been the most anti-business General Assembly that I have been, by far. But I can tell you, nobody on this side, even though some do sign paychecks, some don't, was against that want to see school shootings. We all are against those. And yes, so sorry to the testimony from Kelsey or the loss of her daughter killed with a gun. We did not hear what kind of gun that was, or I didn't. But I did hear it was purchased as a straw purchase. And that's the point I tried to make earlier. Straw purchases are against the law. They're illegal in the state of Delaware. The point is, the bills we pass today aren't going to stop these shootings. There's several other things we could do to stop these shootings. And that's why we were so against. Senator Lawson put in a bill, 2 or 3 general assemblies that he can't get passed for school security. And it would have made a huge difference in our schools. And with this bill, insurances are going to be almost impossible to get for a gun dealer. I stated that in the committee hearing. I only have one company that will write my store, and that's Nationwide. And I called my insurance agent on my way up here today and asked him if he could testify, and he can't. He's away in a meeting. And I says, what is that going to do to gun dealers with insurance? He said, probably they won't be able to get it. That's going to close them, and I'm very concerned about that. And with the passage of that, I don't want anybody to go through any negligence and not be able to be compensated. But it's going to be very costly to businesses because situations do get made up when it comes to thinking that there's big bucks out there. And this is going to be very costly to business. And with that, I'd like to call Anthony Delcalo up as a witness.
Privilege granted, sir.
Anthony Delcolo, Senate Attorney, Minority Caucus.
You heard my statement that it's going to be costly to business and that businesses probably wouldn't be able to get insurance because of this.
Yes.
How do you see this bill playing with small business gun dealers?
So having been both an insurance defense attorney, having done some personal injury cases, also having represented many individuals who have been subject to truly heinous and atrocious behavior, I can say that there are several marked departures in this bill from basic bedrock legal principles that would make it extremely difficult to secure insurance because of the way that insurance companies evaluate when they're controlling for risk. And I can assure you that most small businesses looking at, being that I also have a part of my practice where I represent small businesses and sort of act as general outside counsel to them, when you look at what they're doing, what their cash flow is, would not be able to withstand some of the judgments that would come through if they fell afoul of this legislation. They would probably go bankrupt. Whether or not any sort of findings by a court would be dischargeable in bankruptcy is something that I'm not prepared to testify to, but what I can testify to are those things that are just market departures. One of them, which is very significant, has to do with attorney's fee shifting. In this country, there's such a thing as the American rule. And that's the reason it's called the American rule is because it's so common with our basic legal system, which is that each side bears the cost of its own legal endeavors, of its own suits. And that includes things that are far more heinous than what is defined in this bill. Knowing or reckless behavior, I'm talking up to and including intentional behavior for things like intentional rape, for things like intentionally engaging in a hate crime against a private citizen, for things like intentional murder. A person is not allowed to get attorney's fee shifting in a suit. So quite literally, somebody could take one of the firearms that we're regulating by this legislation and use it in a violent act, a private individual against another private individual, and commit a behavior that would give rise to a host of intentional torts. Things like intentional infliction of emotional distress, intentional assault and battery, and other types of very, very severe civil actions. And they would not be able to recover attorney's fees under the basic American rule that we have. There are other things that I can elucidate, and I think it's worth doing so because they're material examples for our consideration. I've represented individuals in cases who have been put in rooms and screamed at to the point, and kept in those rooms and screamed at to the point where they have defecated themselves, people with disabilities. And in those cases, I was not able to recover attorney's fees because of the nature of the claims. And that is, deeply disturbing and horrendous behavior. And yet, for these claims and for those degree of injuries and for the level of harm, they're not able to cover attorney's fees. So here we're saying that we're not going to hold the person accountable who actually goes out and does the specific horrendous activity with a firearm that leads to and is part of the chain of causation here. We're not going to require attorney's fee shifting there, or require their homeowner's insurance policy or any other coverage to pay for attorney's fees. We're going to, however, require the person who's involved in the sale or the manufacturer or so forth to do so. And that's a really marked departure, Senator, from the American rule. And I think it presents a deep concern in terms of the ability to secure insurance coverage. The other issue that is extant is that we talk about recovery of reasonable attorney's fees for the Attorney General's office in the event that the Attorney General brings an action to address a public nuisance. So even though the Attorney General's office is the largest law firm in the state, and they have some of the best and most exceptional attorneys, I've litigated against many of them on the civil side, and believe me, they're worth every penny they're paid. We should probably pay them more. What I can say is that they're all on payroll. So there are no attorney's fees in association with an action brought by the Attorney General. And yet this creates, as a remedy, as I read this at line 86, the ability to recover an attorney's fee in addition to the compensatory and punitive damages that would be possible in an action brought by the Attorney General. The other issue that raises a lot of question marks for me as somebody who occasionally goes into Chancery Court and deals with things like injunctive relief, which is an extraordinary remedy whereby the court actually provides an order that compels a private party to take action or to not take action. That is an extraordinary remedy. And it's one that has a high threshold if you want to get it. And it's so extraordinary that we don't allow all of our courts to do that. We only allow the Chancery Court to provide that sort of injunctive relief because of the unique expertise of that court. Here we have a situation where we're talking about a person who has been damaged being able to get injunctive relief, a private citizen who has been damaged being able to get injunctive relief. And I'm not entirely sure how that works with issues of standing and how the Chancery Court has evaluated when injunctive relief is appropriate, because in most cases, when you've got somebody who's injured, there's a monetary issue that is associated with that, and there could be punitive damages potentially if it was particularly egregious, such as, for example, if there was a reckless act or a knowingly improper act, certainly punitive damages. But if the damage has already been done and they've already been injured, I'm not sure how providing a private citizen with the ability to pursue injunctive relief would relate to the injury that they've suffered. I'm not sure how this bill reflects the well-established case law and ancient precedents that we've built a reputation on in this state as having the only state that has its own separate constitutionally mandated Chancery Court. So for that reason, I am deeply concerned about how even a relatively large business, but certainly a small business with employees and a payroll to pay and all the other considerations with the bill as drafted could ever withstand paying for the insurance premiums that would need to be paid in order to make the coverage viable for the carrier to provide it. I know how expensive something as ubiquitous and simple as workers' compensation insurance is, which is something that every company is required to have in this state. And with it being that expensive, comparing it to something like this, where you have, and that's a good example. In workers' comp, we have caps on attorney's fees. There's actually a cap in workers' compensation, and I think it's adjusted each year by the Department of Labor. I believe right now it's somewhere around $11,000 for recovering benefits from people who deal with pretty significant injuries, things up to and including death. And we have caps on attorney's fees in the context of workers' compensation. So we have a cap there. There's no cap here. And I know how expensive comp insurance is. So for a situation like this, where we have attorney's fee shifting, the ability of the Attorney General to recover attorney's fees, even though they have attorneys on payroll and they're therefore not incurring attorney's fees, as well as the concerns with standing in the context of chancery court and injunctive relief for a private individual. For those reasons, I don't see insurance coverage being available. I don't see it being affordable for a small business. And I can, again, assure you that with the expense of what it takes to litigate a case where you've got the need for things like medical experts to testify about the nature of injuries, you're going to have an expert to testify about the standards of care and the sorts of behavior that's acceptable or not acceptable in this context. So that's at least 2 experts that are likely in a case of this sort, both of which can have fees that are approaching that of the attorney in some cases that are working on the case to prosecute the action. So when you talk about the ability to recover attorney's fees, costs, court filings, deposition fees, which can run up into the tens of thousands of dollars depending upon the number of witnesses, you're looking at one claim. And because of the way this is drafted, that a business, my recommendation, if I were giving it to them, would be to close up shop. That's all I have.
Woo, there.
Thank you. So
Senator
you see this as an attorney the same way I see it as a business person and the same way my insurance agent sees it. Any other questions for the witness? I move the witness to be excused.
Senator Lawson of the
Oh, I'm
witness.
sorry.
Is this a gold mine for litigation?
Absolutely.
Thank you.
I mean, I would certainly say that, with the way this is drafted, I certainly believe as an attorney with a private practice, I work very hard and very long hours, that, all of my colleagues should be able to recover an appropriate amount for the time and effort they put in. But this, to me, runs the risk of going away from that American rule and the basic principles of equity that we have in our system of justice in Delaware, and going into the realm of providing a potential windfall, not for the person who's injured, but for the litigators involved.
Thank you.
So the goal behind this bill could be to close the small gun dealers.
I don't know if that's the specific goal, and I will not deign to opine or speculate about the intent of anyone who's introduced this measure or who's sponsoring this measure, but I will say that to me is a likely outcome.
Thank you. You can be excused.
Witness is excused. Senator Townsend. Oops, Senator Hocker, I
sorry.
apologize. Thought you were done.
As a business person who started business 50 plus years ago, I got involved in politics because I know with the rules, laws, and regulations, no one could do what I and my wife and I have done. It'd be impossible what you'd have to deal with. And I hate to see more and more and more keep added to it. I'd love to see a young couple be able to start business today and grow every day. It's impossible. And with that, I hate to see us vote on this bill because that's another costly and detrimental bill to small business.
Senator Townsend.
Thank you, Madam President. I want to note that I have not heard that gun sales in New York have taken a hit, which is a jurisdiction that has this kind of framework, which was recently upheld by a federal court. I'm not going to read in its entirety or maybe even quote at all a statement from the Delaware Business Roundtable issued on June 8th in support of the gun legislation package, the majority of the items of which we have voted on today or will continue voting on today. But it certainly was heartening to see, and I think just the tragedy in Uvalde and the tragedy in Buffalo and the tragedies that keep going on, and who knows the details in Birmingham, to Senator Poor's point. But to see a business group at the Delaware Business Roundtable issue a statement for how they support the gun legislation package, because things have to change, and they don't use this exact wording, but the layered approach is critical, and this is a key part of it. And I think I might agree with some of my colleagues on the other side if this is a bill about strict liability that seemed to be just kind of punitive and sort of no questions asked. You are going to be held liable because there is the epidemic of gun violence, and we want to do whatever we can. This says if you are engaged in reckless conduct, if you are engaged in conduct that knowingly lead to harm, then you might have liability. And part of the issue of attorney's fees is because access to the courtroom door is also important. So there are plenty of times in which someone cannot afford an attorney, and the knowledge that attorney's fees would be covered can be all the difference in the world between an important individual and societal problem even having its day in court. And this is not an unprecedented approach. And I think in the wake of what we are facing right now with regard to gun violence near and far, it's important to take steps like this to try and ensure that reckless conduct, negligent conduct, conduct knowingly leading to harm are ones that might be able to be redressed, period.
Senator Richardson, Senator Lawson,